So welcome to House Judiciary Committee, Tuesday, March 4th. Happy to have everybody here. We have 2 bill hearings today, and we'll just get right at it. Looks like it's not going to, I mean, we'll see, but looks like it's not going to be a terribly long day, which is great because I think starting probably next week, it's going to get longer and longer as we just really narrow in on our time. So I will go ahead and open the hearing on Senate Bill 135 and ask Jason Thompson, our revisor, if he would give us a bill brief.
Thank you, Madam Chair. Good afternoon, committee. Senate Bill 135 deals with precedents of child-related orders issued under the Protection from Abuse Act. You can see that the bill is amending KSA 60-3107. It's a procedure statute in the Protection from Abuse Act. The current law in subsection C and where the changes are can be found at the bottom of page 2 and then on to page 3. There are certain orders that cannot be modified on ex parte application or on motion for temporary orders. There's some specific exceptions to that, but more specifically, there are certain orders that are subject to modification for good cause, including immediate and present danger of abuse to the plaintiff or minor children. That is good cause. The bill retains these prohibitions on modifying orders by ex parte or temporary orders, clarifies that orders relating to legal custody or parenting time, orders relating to the best interest of a child, and orders issued pursuant to the revised Code for Care of Children or the revised Juvenile Justice Code shall take precedence over a similar order issued under the Protection from Abuse Act. So it kind of clarifies which orders take precedence there. It also provides that on sworn testimony showing good cause, Protection from Abuse Act orders may modify orders related to legal custody, residency, and parenting time that have previously been issued for the determination of parentage or divorce, separate maintenance, or annulment. And also on sworn testimony showing good cause, orders under the Protection from Abuse Act may modify interlocutory orders that are issued under KSA 23-2707, which is part of the Family Law Code. I will note the bill also retains that provision about immediate and present danger of abuse to the plaintiff or minor children, that is good cause for modification of an order, even under the bill as proposed. It would take effect on July 1st if adopted. It was requested for introduction over on the Senate side by the Coalition Against Sexual and Domestic Violence, went through the Committee on Judiciary, and passed the Senate 39-0. I'll stand for questions.
Okay, thank you, Jason. Committee, what questions do you have for our revisor? Anything? Representative Lewis.
Thank you, Jason. So the Kansas Judicial Council tells us in their 2 pages that this is really not really a substantive change, except in 2 specific instances. Is that my? Just looking at the bill and the italics, it seems more substantive than that, but maybe you could tell us.
Madam Chair and Representative, so a lot of the, well, I wouldn't say it. Some of the language that is stricken is reproduced in other areas. So I was trying to highlight a couple of those pieces for you, such as good cause being when immediate and present danger of abuse to the plaintiff or minor children is good cause. That is in the current law and it's preserved. It's just moved to a different place. Much of the other precedence is established. You're not allowed to modify, not subject to modification on ex parte application or on motion for temporary orders is in the current law. And then there's this huge list of orders. So some of that is repeated just in slightly different form. So I think they're probably very accurate when they say there's only a few changes here. Some of it is just restructured or made clearer. So I tend to agree, I think, with what they've said in their testimony.
Thank you.
Okay, committee, any other questions? Okay, thank you, Jason. Okay, we have two proponents. I'll go ahead and call Ron Nelson from the Kansas Judicial Council. Welcome to our committee. Glad you're here. Is your microphone on? Yep. Okay.
As you indicated, Representative, there are no substantive changes in this bill except for the inclusion of guardianship proceedings. In 2021, the Judicial Council requested that the Family Law Advisory Committee look at the protection from stalking statutes and the protection from abuse statutes to see if we could consolidate or simplify those two acts and possibly put them all together. Well, what the study committee ended up doing was basically deciding, number one, that the two acts should remain separate, and then there were only some other slight changes. The one significant change, if you will, that the committee ended up deciding upon was that this statute, 3007, is very important for self-represented parties to know and understand. And because of the bill has made changes over the years, not to make it more clear, but simply to add other provisions and add other things. And so the drafting committee for the Family Law Advisory Committee decided that we would restructure the statute to make it more simple language, to make it more understandable, to make sure that it covered more instances, guardianships, because guardianships, again, were not included in that. And there are some situations where there is an abuse situation with a guardianship, and there needed to be a way to cover those matters in protection orders instead of having to go through the guardianship proceeding. As I indicated, the one substantive change in this bill is the inclusion of guardianship proceedings. Guardianship proceedings have not previously been included. That basically is my testimony as indicated. There is one very technical matter. There was a misnumbering or a lack of numbering. So on page 2, line 26, it should include parent C, close parent 1. And that is it. If there are any questions, I would stand for questions.
Could you repeat that numbering, what you just said?
Yes, on page 2, line 26, it should read parent C, close parent, parent 1, close parent.
Okay, thank you.
Yes.
And then where, can you just point out I'm assuming it's on page 3, which line has the guardianship added to it?
Yes. I don't remember where that is specifically. It doesn't, as I recall, it doesn't include guardianship. It just includes any other kind of matter regarding
Okay, no wonder I
child.
was having trouble finding the
Yes.
word. Okay, and where's the any other, just so I'm clear on that?
That is, any order entered under the Protection from Abuse Act may be modified by a subsequent order. I think that's referenced in my written testimony. Page 3,
Mm-hmm.
7. Page 3, line 7, I believe.
Oh, sorry, page 3, line 7. Okay, great. Any action? Got it. Okay, thank you. Okay, committee, do you have any questions for Mr. Nelson? Anybody? Okay, thank you. Appreciate you being here.
Thank you, committee.
I'll now call Michelle McCormick from the Kansas Coalition Against Sexual and Domestic Violence. Welcome to committee again. Glad to see you.
Good afternoon, committee members. Michelle McCormick, Executive Director of the Kansas Coalition Against Sexual and Domestic Violence. And I'm relieved you called Mr. Nelson first, as I am not an attorney, just as a reminder. It's a very legal statute, but it does come at the request of our coalition. We work in partnership with the Judicial Council and brought forward to the council that we learn from our partners, whether they're victim and survivors directly, the victim advocates that we work with, the attorneys that support them, that basically this law was confusing, and it created confusion and perhaps was creating just different application of the law across our state. And so anytime there's a lack of clarity when it comes to protection orders and the impact of these orders on survivors and their children, of course, we're concerned that their needs aren't being met. And so we worked with the Judicial Council to support their work in clarifying this language so that when there are child custody cases and protection from abuse order cases, that everyone's clear about which order is taking precedence. And so that is the very plain language version of why we requested this for you all for your consideration. And I'd be happy to answer any questions that you might have.
Okay, thank you. Committee, what questions do you have for Ms. McCormick? Anybody? Trying to find someone. Okay, well, I guess it's really clear then. Thank you so much. We appreciate you being here. Okay, we don't have any written proponents. We don't have any opponents or neutrals. So I will go ahead and close the hearing on Senate Bill 135. We appreciate you proponents being here. Thank you. Okay, committee, I will now open the hearing on Senate Bill 138 and again call on our revisor to give us a bill brief. Thank you, Jason.
All right, thank you again, Madam Chair. This one's a little shorter bill brief. Senate Bill 138 requires search warrants to be issued only on the statement of facts sufficient to show probable cause made by a law enforcement officer. You can see that the bill amends KSA 22-2502, that is the Criminal Procedure Code statute relating to search warrants. You can see there the current law in subsection A provides that a search warrant shall be issued only upon the oral or written statement of any person under oath or affirmation, and then goes on from there. The bill would amend that to read that the warrant may be issued only upon the oral or written statement of a law enforcement officer under oath or affirmation. So that change there in line 10 is the entire change in the bill. I would note that the bill would take effect on July 1st if adopted. And this one came to you in the via the Committee on Judiciary, requested by the Kansas County and District Attorneys Association and passed the Senate 40-0.
Okay, great, thank you. Committee, any questions? Representative Osman. Yeah.
So yes, thank you, Madam Chairwoman. Thank you for your explanation. How would this affect anonymous tips?
Madam Chair, I'm not sure.
If the search warrant is predicated upon an anonymous tip, would the law enforcement officer now need to affirm a tip that they might not be able to verify themselves at the origination point?
Madam Chair, I'm not sure how that changes under this. My understanding was that this is just saying that the law enforcement officer under oath is going to state facts sufficient to show probable cause. It's more about who is making the statement under oath rather than what the facts are. But if I'm misreading it or if it does affect it, I hope the conferees will get into it. Yeah.
Representative Lewis.
Yeah, I might just address that. I think Jason's right. You know, it's normal for a search warrant or an arrest warrant affidavit by a law enforcement officer to state what other people have told them that aren't law enforcement officers. I don't read this as saying anything more than when you go for a search warrant, you can't take the affidavit of a non-law enforcement officer in, but the law enforcement officer could rely on, and often does rely on, statements from non-law enforcement.
Thank you, Representative Carmichael.
The distinguished barrister from Finney County and I are in agreement, so I don't have a question anymore.
Okay, thank you. Any other questions?
I think that's the second time. I just want to
Great.
mark.
We're on a roll here, definitely.
And it was sincere this time.
Yes, you both have to bring treats if it happens again, so for everybody. We'll have a party. Okay, any other questions for our advisor? Okay, thank you, Jason. Okay, I will now call Todd Thompson from the Kansas County and District Attorneys Association, and that will be on WebEx.
Thank you, Madam Chair, committee. Thank you, Jason, for the synopsis, and Representative Carmichael and Representative Lewis for answering that question. That is the way we, at least I would view it. I believe Mr. Breitenbach would also agree with that. We brought this bill forward because the freedom from unreasonable intrusion by the government is considered to be one of the most important individual rights protected by our U.S. Constitution. This bill would further protect that from a misuse and potentially irreparable harm in the current version that we have. The created risk is that an affiant could potentially maliciously or by sheer ignorance fail to exercise the due care or lack of knowledge necessary to draft worthy of intrusion, and will create a risk created by this, unaware, would be that intrusion of an improper investigation as the basis for the affiant, and that a detected neutral magistrate or judge will rely on when issuing an order, mandate law enforcement agents to invade someone's reasonable expectation of privacy. Law enforcement agents are particularly trained and understand the proper and current standards to be used in investigating something that would necessitate a search warrant. The investigations they conduct are on a daily basis, and law enforcement agents are up to date with current trends, laws, and it's their training experience in an area that they routinely face with legitimate consequences that they could face if doing a improper search warrant. At this point, we are allowing anyone to do that. And the byproduct of the bill also protects law enforcement agents from being forced to execute warrants regarding a matter that they may not find to be appropriate to pursue, and taking a risk to them, or whether they do that for strategic reasons, their own safety, or for the general public. As such, this bill protects the reasonable expectation of privacy of all Kansans, and ensures the due care is given before a warrant is issued, and it safeguards our rights to the Constitution and the Fourth Amendment. With that being said, I'll probably stand for questions or after Mr. Breitenbach speaks.
Okay, thank you. Since we just have two proponents, I think I'll go ahead and let the committee ask questions now. So committee, do you have any questions for Mr. Thompson? Representative Barrett.
Thank you, Madam Chair, and thank you, Mr. Thompson. It sounds like a great bill. I was just out of curiosity, have you had a case where the affiant was not a commissioned law enforcement officer? And I mean, are you able to give an example? Again, just out of curiosity.
That is a great question, and I saw Mr. Breitenbach smile. We both are the two counties that have had this happen to them. It related to, mine was a civil case of what's called a 60-1507 or ineffective assistance of counsel, which they reviewed. And so the fact that the judge granted it and we've seen that it's being noticed, we are concerned that this will become a greater problem.
Thank you, and thank you, Madam Chair.
Yep. Any other questions for Mr. Thompson? Okay, thank you. We appreciate you being with us.
Thank you, committee. Thank you for letting me present this way.
Okay, and now I will call Aaron Breitenbach on behalf of Mark Bennett, the DA for the 18th Judicial District with the Kansas County and District Attorneys Association. Welcome to committee.
Thank you, Madam Chair. And again, thank you, as Mr. Thompson said, thank you for allowing me to appear remotely. This saves me about 4.5 hours of my life, so appreciate that very much. Todd summarized the bill quite well, as did Jason, for that matter, as far as what it is. That it's a relatively simple fix to really make the statute comport with what some of us learned back in high school civics. You know, what a search warrant is, what it's intended to be, and who should have that power, or at least who should start that process. And as Todd said, you know, sadly, we know that even law enforcement officers will sometimes make mistakes, and there's a process, there's an effect on their career, there's a whole structure built around trying to remedy those problems. But one could imagine situations, and as I was talking to someone yesterday, I could think about a domestic case, right, where a person would love for law enforcement to go find something in their ex's house that might help them in the domestic case, and so they'll swear out a statement that may or may not be true, but let's even assume that it is. Then compels law enforcement to go essentially do forced discovery that's going to influence a domestic case, right? There are other circumstances like that where you could see that people could have varying motives, but through their actions compel law enforcement to use their resources and endanger themselves to conduct searches that realistically would never result in a criminal prosecution, but could inform some other motive or process that has nothing to do with what law enforcement has as their priorities and mission, let alone the best interests of the community. So we ask this bill be passed, and I stand for questions as well. Thank you so much.
Okay, thank you so much. Committee, do you have any questions for Mr. Breitenbach? Anybody? Okay, I think we're fine. So, and you kind of gave an example with Representative Barrett's question. So was that sufficient? Yeah. Okay. Yep. Thank you so much. We appreciate you appearing, and we will be working this bill, I'm sure, sometime in the next days or week. So.
Thank you.
Okay. Thank you. Appreciate you being here. Okay, committee, again, no written opponents, or neutrals. So I'll close the hearing on Senate Bill 138. I think this is a record for us. So enjoy that. Make sure our agenda for next week will come out tomorrow. Make sure you take a look at that. Again, Thursday, we do have one bill hearing. Tomorrow we have bill hearings. Thursday we have one bill hearing, and I might work anything that we have heard so far. Honestly, I'll try to give you more information tomorrow on what bills I plan to work on Thursday, but it could be any of them. So make sure you're getting with Jason in case you have any amendments or anything. So, okay, any questions, anybody?